a.m. on Wednesday, September 17, 2025. I'm going to call this meeting of the State Ethics Commission to order. I do want to point out before we actually get started on any substantive issues this morning that we do have a new commissioner with us, Ms. Dana Dement. We're really glad to have you here. We look forward to working with you on these matters, as long as you can put up with the group of folks that sit up here. Okay?
Thank you. I'm honored to be a member of this committee, this commission. I look forward to serving the state of Georgia. Enjoyed meeting everybody and looking forward to your leadership.
Okay. Thank you very much. I'm looking at it. We've got an agenda here before us. It looks like it has 11 parts to it. Has everyone had an opportunity to review that agenda as it was sent to us earlier? Does anyone have any changes as presented this time? All the consent orders are going to remain consent orders? We've got signed consent orders on everything, is that right?
Yes, that's correct.
Okay. Hearing no changes being requested to the agenda, I'll go ahead and move to adopt the agenda.
Okay.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right. We're going to move to item number 2 on the agenda then. We've got the meetings of the commission, the minutes from the commission meeting of Thursday, June 12, 2025. The only commission members who were present for that meeting were myself, Commissioner Thompson, and Commissioner Wise. So those would be the only 3 that would be voting with regard to the minutes. Have the 2 of you had opportunity to review those minutes from the meeting in June 2025? Do you have any changes, questions, comments, or remarks with regard to those minutes as presented? All right, I do have a couple of things. First, with respect to Nicole Messiah, at our last meeting in June, we actually continued that case until a later date, and I noticed that it is not on our agenda to be heard this morning. Mr. Knittel, can you just give us an update of what is going on with that case?
Yes, thank you, Mr. Chairman. If in our last meeting, as you recall, we partially went through that hearing. Ms. Messiah has provided me paperwork. I think we have this case probably worked out. But as this was a meeting in Savannah, I believe the commissioners decided it would be okay to have that in December, if I recall correctly, because she's more local to Fulton County.
Okay.
And that would be closer for her. So that's what we anticipate in that.
Very good, and I think you're correct on that now that you mention it. I've also marked 24-0086C. That was in the matter of Joseph Mark. That was one where we actually adopted a stipulation that was entered into, finding that there were reasonable grounds. Has that been sent over to OSA yet?
I'll have to verify that, but I can let you know in a few moments here.
Okay.
I just have to get on our shared drive.
That case was just a little bit different, that's why I'm pointing that one out as opposed to others, since we had that stipulation. At least since I've been on the commission anyway, I don't remember us ever having something in that nature, so I didn't know. I'm curious what's going to happen when it gets over to OSA. The last thing I want to address, well, I have 2 more things. With regard to the administrative dismissals from the last meeting, there was a 2-1 vote on the Ben Burnett case to actually remove it from the administrative dismissals. What's the status of that one? Mr. Knittel, if you know?
That has, I don't know the entire status of it. Mr. Baywall was presenting that particular matter. However, if it needs to be presented again, it wouldn't be until December. Mr. Baywall is not available today, and he has the details in that particular matter.
Okay. The last thing is on page 3 under the consent orders. The minutes reflect that a motion was made to adopt consent orders as presented with the exception of 4C-4G. Ms. Easterwood, can we make that an and between there? The way that it's on here, I just thought that it sort of looked like we adopted all of them, except for the ones that were 4C through 4G, and I just want to make sure that there's not any confusion with that one. And thank you very much for the work on the minutes. With that one change then, do I have a motion? to adopt the minutes? I got a motion. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right, that takes care of the minutes. Item 3 on the agenda, these are going to be consent orders. It looks to me like, Mr. Knittel, that you have the first set of cases that are included on here. Looks like it's item A through item F. Is that correct?
Yes, that's correct.
All right, let's go ahead and get yours addressed then, please. First, let me ask, is there anyone here with respect to the following cases? It's Charles, is it Burgoy? Am I saying that?
Bourgeois.
Bourgeois, okay. Go Big for Macon-Bib, Inc., Chad Jones Smith, Kenya Wicks, Derek Mallow and Friends of Derek Mallow. And I appreciate you being here this morning. Thank you very much. Are you going to want to make any kind of statement or anything of that nature with respect to the case? Okay. Mr. Knittel, go ahead and proceed then.
Cindy Mills, right?
Yes, I'm sorry. And Cindy Mills and Citizens for Cindy. Anyone here on that one? All right, thank you very much, Commissioner Burge.
Okay.
Okay, go ahead.
Thank you. So the first case, 25, which is position A, Charles Bourgeois, 25-0037-C. That was a third-party complaint, and an amended complaint was then filed by our office. Mr. Bourgeois is a current candidate for Atlanta City Council, District 9. There's one violation in this case for failing to file his DOI's declaration of intention with Atlanta Municipal Clerk prior to accepting campaign contributions in violation 21-530G. The penalty in this case that was agreed upon is a $500 civil penalty. And just some details about this particular matter. The respondent did file an RC and registration of candidates committee with the State Ethics Commission because he has a campaign committee as well. He filed that on March 1st, 2025. The campaign mistakenly believed that was what they needed to do for their DOI. Because it's a municipal election, the law specifically requires them to file currently with the DOI with the municipal clerk. That's what needed to happen in this particular matter. Mr. Bourgeois' campaign did file a DOI with the local filer on April 18th, 2025. After fully reviewing this, speaking with the campaign people, and he did provide all his records, it was clear to me that it was simply an error. He didn't have any intent to try and circumvent the law. In fact, his CCDRs that he provided were actually very well done compared to some others that I've seen. So that was the violation in this case. It's already been, the penalty's already been paid, and we'd ask you to take that as it is.
Commissioner Thompson?
Did he file a DOI with the Ethics Commission?
No, he did not.
He just filed an RC?
Correct.
But isn't the DOI and the RC combined, or did he file it on paper since he was local?
No, he filed electronically. RCs, when a candidate files an RC, that has to get filed directly with us, and it's filed electronically.
I understand that, but the way the system works, you file in your DOI at the same time you do an RC. So I don't know how he got past filed a DOI with the Ethics Commission.
Well, there is the form on our current system, which is being replaced, as you know. It is. The form, this is where the confusion lies. The form itself, the electronic form on the top of the page, it does indicate declaration of intention to accept campaign contributions.
Right.
The second page is the RC. The current system requires you to file all of those matters, which get filed with us. However, the issue becomes that this is a local candidate.
No.
So the only,
Wait, I understand that part. But, so my question was the DOI filed with the Ethics Commission? And you initially said no, but now you're saying yes.
I'm still stating he did not file a DOI. He filed the RC. It is part of the same 3 pages that he
Right.
files.
And it says DOI on top, and you have to fill it out.
It does say that.
And you have to fill it out.
Right, but
So it
he
is
needs,
filed with the commission, is my point.
but he by law is required to file that directly with the municipality.
So you're saying because the law specifically says the DOI has to be filed locally, even though he filed one with us, that's why?
It's not
Yes.
valid. It's like if someone's running for. It's not valid. It's like if someone's running for the state house and they go to the city clerk and file a DOI and then say, well, I filed the DOI with the city clerk. Well, that's not where it's supposed to be filed. It's not a valid declaration of intent. If he files a declaration of intent with us, but the law requires at the municipal level, unless he files at the municipal level, it's not validly filed. That said, we took a pretty even-handed approach to this case because, as Mr. Cannell said, it clearly wasn't an intentional thing. It was a confusion about where forms needed to be filed, which, Mr. Vice Chairman, as you know, is why we passed a law this year to bring it all back to the state soon, so that everything's sort of in one clearinghouse. But whether he filed it at the state level or not is sort of immaterial to the law, I think.
And this was a third-party complaint.
Yes.
Yeah, okay.
Any other questions on that one? No. Okay.
Oh, well, let me call the numbers, I'm sorry.
Okay.
That was case 25-0037-C.
Yes.
I'm going to call the next case as 25-0031-C. It's in the matter of Go Big for Macon Bib Incorporated.
Yes. That was a staff-initiated complaint. This is a county level.
Excuse me, Mr. Cannell, I'm sorry to interrupt you. This
Oh.
Dana Dement. Would you speak up just a little bit?
Yes.
Or turn your mic on? Sometimes I was having difficulty hearing you.
Okay. I'll speak louder
you.
and clearer. Thank you.
Thank you.
So this is a county-level ballot question committee that was related to a SPLOST referendum in Macon-Bibb County. There's one violation, and that is as a county ballot question committee, they received a direct contribution from a government agency in violation of 21.530.2C. The penalty amount that was agreed upon in this matter was a $1,500 civil penalty. Essentially, in this case, this was a mistake on the part of Go Big for Macon Bib when they received a $50,000 influx of cash from the Macon Industrial Authority, and they counted it as a campaign contribution, even though that's not what it was intended to be. Commission members that were present at the last hearing, there was a collateral case with this regarding the Macon Industrial Authority. This is the second part of that. In any event, the Macon Industrial Authority legally contributed the money for the purposes of the efforts to inform and educate voters of an impending SPLOST that was about to happen in that county. However, Go Big registered as a ballot question committee and then reported the receipt of those funds as a campaign contribution and expended it, some of that, or for campaign advocacy, which they're not allowed to do. So the result of that is we've agreed to this penalty of $1,500 as a civil penalty.
Mr. Chairman, if I may, the one thing I would point out for the commissioners, it was roughly $50,000 in government dollars that were given to the SPLOST referendum committee. Those were actually, however, private dollars. Macon has some setup where private donors can donate directly to the industrial authority, which I think a lot of cities and counties don't allow. Had those been $50,000 in tax dollars, this would have been, we probably would have pursued this more aggressively. But because they were not, taxpayer monies that were being utilized, we felt this was an appropriate figure. Just wanted to put that on the record.
Anything else? All right, item C, case number 22-0104-C. It's in the matter of Chad Jones-Smith. Mr. Knittel?
Yes, Mr. Jones Smith was a candidate for Atlanta Public School Board of Education in District 2 in a special election in 2019. He lost his election. In this case, there are 3 violations. One for failing to properly disclose all campaign contributions under violation of 21.534B1A, and also a violation for failing to properly disclose all expenditures made by the campaign in violation of 21.534B1B. And then the third violation for failing to timely file December 31st, 2019 CCDR. The penalty in this case is one late fee of $125 and a civil penalty of $400 for a total of $525 that will be paid. This is a campaign which raised and expended less than about $4,000, just to give some context to this. And the respondent, when he ran for office, apparently used PayPal as his banking system. The commission got this or started this complaint approximately 2 years after he lost his election. And so when he got around to trying to find records, he said he wasn't able to get them anymore from PayPal. There was a hearing on this matter. It did get referred to the Attorney General's office, and we were in the process of having a hearing. I believe the hearing would have been a substantial distance from Fulton County, so there have been quite a bit of travel and expense involved. And this gentleman did provide the records that he could obtain. Again, he did not have a large campaign. It was about $4,000 total.
And I'm assuming by that time, any type of campaign account was
It-
done?
Exactly, that's correct.
All right, item D, case number 25-0013-C, in the matter of Kenya Wicks.
Yes, this was staff initiated. Ms. Wicks is a Georgia Senate in District 34. It was one violation. She failed to file a January 31st, 2025 CCDR in violation of 21534C2A. The penalty in this matter that was agreed upon is a $125 late fee and a $200 civil penalty for a total of $325. That's all been paid. This was part of the audit that we conducted of the Senate. Senator Wicks provided all the requested financial documents and filed the missing CCDR within 5 days of receiving the complaint. Additionally, I just want to point out, because she made a point to tell me that she worked extensively with the folks in our education area of the commission, and she said that they were great assistance to her. She had several filing questions. They helped her go through that process, and she had a lot of praise in particular for Ms. Goldsmith in our office. Said that she was very kind and incredibly helpful with the questions that she had. So I just thought it was worth letting the commission know that sometimes we do get some nice comments from folks.
Okay. Item E, it's case number 25-0010-C. It's in the matter of Derek Mallow and Friends of Derek Mallow.
Yes. Mr. Mallow is State Senator of the 2nd District. He's present for the hearing, as the Chair commented. This has 6 violations. Failed to file 5 CCDRs in the 2024 election year, the April, June, September, October, and December, and then a one non-election year CCDR for January 2025, and failed to timely file a personal financial disclosure statement covering the calendar year 2022. So in total, there's 6 violations. The penalty that was agreed upon is $875 in late fees and a $125 civil penalty for a total of $1,000. Senator Mallow provided all the requested bank and campaign account documents and filed the outstanding reports. Also filed the PFDS as well. This matter, he seems to be on track and has everything as it should be in his system now.
And if I remember correctly from the last meeting, he was very cooperative throughout the process, right?
Yes, he was. He was very cooperative. He communicated well with the office. I just had a chance to meet him, and we talked several times.
Okay.
Did he have any explanation as to why the serial failures, April, June, September, October?
I don't know if he had some difficulty working through the system. I'm not entirely sure what the reason was for that. There's time to time where folks simply, I don't know if they forget to file or don't file, but I don't know the particular reasons as to why those were not filed.
I was just wondering, did he realize that he'd missed one, and then you'd get back on track, or how would you continue to miss those disclosure reports?
Did you want to say something, Mr. Mallow, or no? I'm sorry.
Yes,
Sure.
thank you.
Here you go. I didn't want to speak for you.
Thank you to the members of the commission. I had a young lady that was doing those reports for me originally, and she got behind on doing them. And by June, when I realized that she was not getting them done, I took it upon myself to do them. But my daughter in August was hospitalized for IBS and was in the hospital for about 2 months at that time at the pediatric hospital here in Savannah at Memorial. But that has no standing. I should have gotten the reports in, and I accept the accountability to make sure the reports get in.
Fair enough.
Yeah, and I appreciate, the report, and I hope that, I hope she's doing well.
She is. She has chronic IBS now, so we go in and out of the hospital at times.
Okay, okay. Well, again, thank you very much for those comments. Anything else on this case?
I will say something too. No two cases are the same, right? The facts always, and so when we see a case where there are numerous misreports, part of what we look at in terms of making a recommendation on an appropriate penalty is, well, was there a significant amount of activity that was being shielded? I think there's a difference in you have 6 misreports and, you raised 10,000 versus 2 million. And how was the money? And Senator Mallow didn't have opposition in 24, so not to insult your fundraising, but it's not like there was a lot of information that wasn't being shown to the public, and so that's something we also took into account in this case.
Item G, case number 25-0040-C in the matter of Lester Miller.
I believe we have item F, Cindy Mills, first.
Wow, I've missed that one twice. I'm really sorry. It's case number 25-0004-C in the matter of Cindy Mills and Citizens for Cindy.
Thank you. Ms. Mills is a former Forsyth County Board of Commissioners District 4 member. She retired at the end of 2024. In this particular case, there's one violation. It was for failure to disclose an expenditure of $27,826.86 on her December 31st, 2024 CCDR violation. CCDR, that's a violation of 21-534-I1. In this particular matter, an agreed upon penalty was a $1,500 civil penalty, which has already been paid. And as far as particulars in this case, this was a series of, to try and see how we get there, as Commissioner Dement was asking about the other case. In this particular matter, there was a series of CCDRs that Ms. Mills had throughout several filing periods that had different errors on them, and that's what caused this ultimate issue here. She hired and worked with a filer to go back as far as 2017 in this particular case, and amended reports. They provided all the bank records to me related to this, and ultimately what this resulted in was she had loaned herself money, and I was able to see that in fact did occur, and she just did not account for it properly. But there was a report that she had filed that had this balance of the $27,000, and then the next report it was zero. So that's really what the issue was. Ultimately it was money that she owed herself. And so they were very cooperative, and like I said, it's rare to have somebody go back that many years to try and fix everything to get it correct, and they in fact did that.
Now I'm going to move to item G. It's case number 25-0040-C in the matter of Lester Miller.
And I'll be pinch hitting for Mr. Babel.
Okay.
Okay. So in that case, Lester Miller is the mayor of Macon-Bibb. This is from the 2024 election cycle. He was successful in that. And there are a total of 5 violations of 21-533-B2E for transferring excess contributions from his campaign committee to a nonprofit organization in which he had a controlling interest. In this particular matter, there was I would say there's maybe some gray area related to what controlling interest is, which is kind of where we came out on this case. Mr. Miller believed that 51% is what was needed to have a controlling interest in a nonprofit. Our particular statute is kind of silent on that matter. There's other areas in Georgia law where as little as 25% can be a controlling interest as it relates to nonprofit. He transferred $220,000 from his campaign committee to his nonprofit, And then that money was then spent through an independent committee which registered and reported correctly, and was spent for the purpose of advocating for violence prevention programming in Macon and other surrounding counties. So the money ultimately was spent in a proper manner. It was just that the transfer to the nonprofit, that was what was incorrect and should not have been done. And so the penalty in this matter was agreed upon as a $5,000 penalty.
Commissioner Thompson?
Is controlling interest defined anywhere under our statute or rules?
No, it is not. It's not within our particular act.
What did you mean when you said that in Georgia, it could be 25%? Explain that one again?
Sure. Give me a moment, I'll get to my notes here. So, in the consent order, it kind of talks about it a little more particular. If you look at the fourth paragraph,
Second page?
yes, page 103. To answer Commissioner, Vice Chairman Thompson, our act doesn't specifically define a controlling interest, but elsewhere in Georgia code, it's defined as an equity interest or an ownership participation that accounts for 25% or more of the voting rights or profit interest of a business. And in this particular case, the respondent was asserting that the controlling interest required at least a majority interest, or, more than 50%. And that's where I guess the gray area lies. So this may be something that we could look for doing a rule to define that for within our statute, because there is a gray area with that.
How are we going to be able to put it in a rule if it's not in the statute?
Well, we would take a look at, I guess I don't have the exact of that, but we were,
I can answer that. I think a term in code that is referenced can be defined in a rule, and I think we've done that in other places. I think it's the distinction between a rule versus what is required in legislation is clarification versus wholesale invention. And statute talks about controlling interest. I think we have rulemaking authority to clarify what specifically a controlling interest is. And I think Mr. Knittel is right. The consent order cites where 25% in certain parts of Georgia code constitute a controlling interest. Candidly, there are other parts of Georgia law where 33% is a controlling interest. We didn't come across anything that said it had to be 50 or more, so we felt comfortable proceeding given sort of the nature of this case. But
Doesn't this say the Black's law definition? Black's law?
yeah, I mean,
definition?
Black's law isn't binding. It's
Right.
not Georgia law. It's a general legal
It's a dictionary.
definition
for all 50 states, which of course have different laws within themselves.
So when there is no definition, and it's defined differently or
Sure.
multiple different ways in the Georgia law, which one do you get to pick? Is whatever we want?
So I think we didn't have to get to that point in this case because when we looked at the facts, we saw that 100% of the funding that went to the nonprofit came from the candidate's own campaign committee. The checks were written and cut from the campaign to the nonprofit by the candidate. They were written and cut by the candidate from the nonprofit to the IE. So it didn't seem like you could have defined it at 40%. I think we still felt comfortable making a factual argument if it was contested that this was a controlling interest.
Well, I can see this coming up a lot,
I agree.
especially with everybody
Yeah.
moving offices and stuff. So we probably want to look at, Mr. Chairman, getting a rule or something.
Yeah, what have we been doing? I know that we had this issue before, but are we recognizing consent orders as, I guess, sorry to slice this.
No,
whatever you wanna call it.
because it's like any settlement, right? It's just because two parties agree to a
what I-
settlement doesn't
yeah.
mean that is binding law on everyone moving forward. It's part of a complex negotiation in certain cases where there are different interests that are going to be different in different cases.
Okay. I mean, I think that I fundamentally agree with that approach, but it sure seems that we had a couple cases where prior consent orders were being, utilized for the purpose of trying to show what our rule is. I can think of a couple that Mr. Chalmers did.
Yeah.
Did that way, so,
I'm sure he'll be, enjoy getting a shout out here.
yeah, yeah. Okay,
But to your question, I do think people have tried to sort of wave that in our face to say you have to do X or Y. I don't think that from a legal premise that it's binding. I think it's no different than a settlement, right?
yes, yes, I mean, again, I agree with that, but I know that we've had certain cases where the arguments have at least been made that, this is the way we did it, within a consent order, since we're signing it and agreeing to it, that somehow that's us, accepting that as a rule of law.
Right.
Okay.
Are you I do want to make a comment about this case, but I'll let you.
No,
I will say, statute specifically forbids giving campaign money to a nonprofit that you control, right? And, we helped write that law a few years ago. And the intent was, we don't want people offloading campaign money and then pocketing it. That did not happen here. Had that happened, this would have been a more aggressive fine, I think. $5,000, I think, is appropriate, given that had they just maybe had better legal counsel on the front end, there wouldn't have been a violation at all, because the money went to the nonprofit and then to an independent committee, which it really could have done directly. But our review of the record showed that there was no money, taken or improperly utilized at the end of the day.
Okay. Any other questions, comments on that with respect to that case? All right, next item, it's item H, case number 23-0017-C. It's in the matter of Edward Ted Terry.
yes. Ted Terry was the successful candidate for DeKalb Board of Commissioners, Super District 6, in the 2020 election cycle. This is a commission-initiated complaint. There's a total of 9 violations, 8 violations of 21-534C for failing to file CCDRs on April 30th, September 30th, October 25, December 31st of 2020, and June 30th and December 31st of 2021, and June 30th and December 31st of 2022. And there's one violation for failing to file his calendar year 2020 PFDS. In this case, there were 9 late fees of $125 each for $1,125, and a civil penalty in the amount of $875 for a $2,000 total penalty. This was, let's see. He provided all the, I'm sorry, I'm looking at some notes on this one. Mr. Terry did provide all the financial records that were requested of him in his campaign. He was able to get everything filed after that, and the penalty has been paid in full.
May I ask this, Mr. Knittel?
Yes.
How does the amount of the civil penalty, I'm sure it's a case-by-case basis, but I'm looking at this matter in which the number of violations seems similar to the one we were talking about earlier. But the civil penalty here was $875, and in the other one, the penalty, I think, was $150. How do you determine the amount of the civil penalty?
In this particular case, I think, so there's several factors that would go into it. I think the size of the campaign, meaning the dollar amount, I think it matters as far as what their, $4,000 campaign is very different than if somebody would raise and expend, let's say, $100,000. There's much less to disclose on the smaller campaign.
So this was a more substantial?
This is a more substantial campaign that he had than the prior one. That would be one of the factors. I think the age of this particular case, when the violations occurred, and then when this case came, that also is somewhat of a factor. He did go through and he did get everything filed. And so the election had taken place years before, and he did go back and he got everything filed that he needed to in this particular case, and provided all those records. But mostly in this particular case, his campaign was large, substantially larger than the prior one that you're referring to, as far as the money amount.
Well, Andy's also got, 9 late fees. So you take that 125 and multiply it, so, again, that's going to increase the fine.
Yeah.
Well, I was talking about the civil penalty, though. I think the fees were consistent because they were 125 per violation, but the civil penalty was 875 as opposed to, I think it was 150. I can't scroll quickly enough.
Another consideration we look at, Commissioner, certain candidates have run before several times and certain are sort of first-time, candidates. And there's a little more grace and deference if this is your first time and you made a mistake versus, Mr. Terry's been involved in politics a long time. He sort of knows how this is supposed to work. So that's just one of another number of factors.
I'm going to pull that one out to address separately from the Hicks rule.
Okay.
And again, this is nothing big. There's a typographical problem in there. And so I'm just going to address that separately and, just note that it's a non-substantive change that I think that I can just make in the consent order and, have it adopted in that fashion. Do you have any reason to disagree with me on that? Okay. All right. Next item, case number 24-0127-C in the matter of Jeffrey Lee Powers.
In that matter, Mr. Powers was the unsuccessful candidate for the Carroll County Commission Chair in the 2019 election cycle and the Carroll County Post 5 Commissioner in the 2020 and 2024 election cycles. This is a commission-generated complaint. There are a total of 5 violations. 2 violations for failing to file his April 30th and June 30th, 2020 CCDRs, and then 3 violations for failing to file his final report and termination statement within 10 days of dissolving each of those campaigns. And in this matter, there were 5 late fees of $125 each and a civil penalty of $375 for a total penalty of $1,000. This falls within that smaller campaign area. It was within the $5,000 to $15,000 range, with a fair portion of his campaign funds coming from his personal funding of himself.
Item K, case number 25-0039-C. That's in the matter of Gary Bechtel.
We missed Jay.
My
Chair.
gosh, I keep circling them too soon. Case number 25-0038-C in the matter of Justin Hawkins.
Yes. In that case, the respondent initially filed a DOI for the Georgia State House of Representatives, District 28, in the 2022 election cycle. He began accepting contributions and making expenditures, but then suspended his campaign prior to qualifying. This is a campaign-generated complaint. There are 3 violations. One for violation of Rule 189-3-.014 for failing to file his June 30th, 2022 CCDR. And then 2 violations of 21-534B1B for failing to report and itemize 2 expenditures, one in the amount of $3,095 and the other in the amount of $6,621.70. In this case, there's a 1 late fee of $125 and a civil penalty in the amount of $875 for a total of $1,000 penalty.
All right, now can I go to item K?
Yes.
Case number 25-0039-C in the matter of Gary Bechtel.
In this case, respondent was the successful candidate for the Macon Water Authority Chairman in the 2022 election cycle. This is a staff-generated complaint. There are a total of 8 violations. There's 5 violations of 21-534C for failing to file CCDRs for September 30th, October 25, December 31st, 2022, and December 31st, 2023, and again December 31st, 2024. And there are 3 violations for failing to file PFDS in violation of 21-550 in calendar year 2021, 2022, and 2023. The penalties in this case that were agreed upon were 8 late fees of $125 each and a civil penalty in the amount of $500 for a total of $1,500 penalty.
Item L, case number 25-0057-C. It's in the matter of Miriam Paris.
Respondent serves on the Georgia State House of Representatives, District 142. She's been the successful candidate in all elections for that seat since 2017. This is a commission-generated complaint. There are two violations in this matter. Two violations for failing to file her calendar year 2022 and 2023 personal financial disclosure statement. The penalties that were agreed upon were two late fees of $125 each and a civil penalty of $250 for $500 total penalty in that case.
I'm going to hold this one out and do it separate for the same reason, non-substantive
Okay.
change. Next item is item M, case number 25-0069-C. It's in the matter of Georgia Freedom Fund.
This is a commission-generated complaint. Respondent was a registered political action committee that also made independent expenditures advocating for candidates on ballots in Georgia in the 2024 election cycle. The commission had previously advised in AO 2015-02 that hybrid organizations such as this must register and report both as a political action committee and as an independent committee. And the respondent spent approximately $50,000 in total independent expenditures for candidates in the February 13th, 2024 special election, and then again in the May 21st, 2024 primary election in that time period. Yes, Vice Chair.
Would each one of those have to open a separate bank account? Or is that a later discussion?
That's probably a later discussion, but they would still
That's
have
fine.
to open a
That's fine.
separate bank account. And so in this particular matter, there are a total of 9 violations. One violation for failing to register as an independent committee. 3 violations for failing to file a June 30th and December 31st, 2024 CCDR. And then again, a June 30th, 2025 supplemental CCDR. And there were 5 violations for failing to file 5 reports that were 2 business day reports for expenditures which exceeding $1,000, which were made within 2 weeks of an election. So there were 8 late fees of $125 and a civil penalty in the amount of $4,000 with a total $5,000 penalty, and that has been paid in full.
Oh, it's already been paid?
Yes.
I do have
Where
one
do
question.
Oh, sorry, go ahead.
Would you, I don't want to oversimplify this, would you give me a good example of what you would consider an indirect contribution and a direct contribution that, you know, maybe from this file or, but,
Like the difference.
yeah,
The difference between a PAC and an IE?
Yeah.
Yeah. So a PAC will just cut a check to candidate A for State House. An independent committee or super PAC will not cut a check directly. They'll pay for a digital ad buy on Facebook to go out in the area where that person's running for office, advocating for the election of candidate A. Candidate A is strong on X, Y, and Z issue, so vote for candidate A.
so they would buy their own
Yeah.
robocalls or mailers
Yep.
or ads or billboards maybe,
Correct.
whatever they choose to do.
Correct. And in this case,
Those are both okay, you just have to report them.
have to report it. And
In different categories.
in different categories, different types of reports. And in this case, the Freedom Caucus was registered, Freedom Fund, it's Freedom Caucus. They were registered as a PAC. Within the PAC reports, they were disclosing independent committee activity. But those are different reporting schedules, those are different details you need to include. So it was in violation because they weren't properly disclosing what they were.
So we're talking almost 53,000, around 53,000 of expenditures. I'm not talking about the 2, just the ones you have listed. So $53,000, and the civil penalty is only $4,000. It comes to a point, we've had this conversation in the past, I think, and maybe a long time in the past, or maybe I just made it up, but it comes to a point that And I know we're not setting like a percentage here, but it's almost like you could do this for the cost of business, right? If you didn't want to disclose it. Because civil penalties, in my mind, is supposed to deter people from doing things like this. And $4,000 for that, I don't see that significant.
I think there are two things that we got to the holistic number of 5K, which is the total penalty. I think there were two things we looked at. One, in the PAC disclosure reports, they were listing who they were supporting. So it was bad compliance work. It wasn't like they weren't trying to tell us. The other thing we looked at is they're now defunct. They've shut down. So following this check, this organization no longer exists. They terminated as a political entity, as a corporate entity, my understanding is. So in some ways, it'd be great to say, let's get a $100,000 penalty, but if you're never going to collect it, it's just kind of for show.
That's the question that I've been waiting to ask. I mean, right before the conclusions of law, it makes reference to the fact that the respondent is no longer active and its registration status has been terminated. So I'm assuming that these, the payment, the fine, was done from personal funds, I'm assuming, right?
I don't remember the check, but I remember being told by the person in charge, once they cut the check, it was over.
I understand Commissioner Thompson's point, though. There's nothing to stop them from doing that however many times. They just shut that particular, entity down and then start another one, if that's the rule. If we're worried about them going defunct and not having any money to pay the fines.
Sure.
Is there some way, if we see that happening, where they, shut one entity down and then, begin another one, that where we can somehow, track it back, or track it to the new organization?
It gets real fact specific, but there is the concept of connected organizations and whether you can tie different groups together in a case. So I don't want to say, yeah, we can do that without knowing what the facts are, but it is potentially an option, yes.
Commissioner Thompson, anything else?
Yeah, one more, sorry. To the chairman's point, do we even try to check if somebody has historically, violated the law before, regardless what the name of their committee is? Do we even check that?
To the extent we can, to the extent we know who
You guys
the-
do look at it.
to the extent we know who's involved. I'm not trying to oversell.
Sounds like a lawyer answer.
Well, look, there's the chairman, there's the treasurer, those have to be listed. If we see names, that are being paid within the disclosure reports as being in charge of the organization, we know who those names are. But I think you would agree that a lot of times the chairman, the treasurer on campaign disclosure committees are not necessarily people super involved with the campaign. And so there might be people involved that were involved with other cases that we just don't know about. But to the extent that we have the information, yeah, we do consider and look into that.
But there's not any flag that pops up. It's
No.
something where we just have to remember those certain folks' names. And again, if you get we get some new folks, on the staff.
Yeah.
They're not gonna recognize those names if that case is assigned to them.
Yeah.
Thank you,
Maybe
guys.
we should ask with this new, the rollout.
Change
that if
order.
there's some-
Change order 2 weeks before? That sounds like a good
Like a
idea.
list of, evildoers or something that we.
Well, I think you can do a database without using the system.
Yeah.
Even if it's
Yeah.
an Excel spreadsheet.
Self-identified.
Stuff like
Yeah.
that.
Yeah, that's a good idea. Internal records that we keep updated.
Yeah, I mean, the challenge is when it's something like this where it's a committee, it's obviously easier if it's a candidate or
Sorry, your
something.
job is hard.
Not saying we can't maybe figure something out, but we do take that into account when we're able to, I think is what Mr. Motti was also saying.
All right, anything further on that case? All right, next is item N. It's case number 25-0051-C in the matter of Cesar Gonzalez. Oh, yes, Ms. Judd, sorry.
Now we start to have some fun.
Good morning. Yes, the next items on the agenda are cases that I worked on and resolved. And so the first case is Mr. Gonzalez case.
Repeat the speak up request.
Yes, absolutely. I'll try to speak louder and lean in. Okay. Did you already list this case?
I just indicated that the chairman would call the case. Did you see?
Yeah, I did.
He called it.
Okay. Thanks, Mr. Knittel. So Mr. Gonzalez was a staff-initiated complaint. He was an unsuccessful candidate for Douglas County Commission Chair in the 2024 general election. His violation was under OCGA 21-534M for failing to timely file his final report and termination statement. He was mostly entirely self-funded and had a small campaign, so his penalty was $250 with the $125 late fee and the $125 civil penalty.
Okay, next item is O, case number 25-0052-C, in the matter of Stephanie Donegan.
Ms. Donegan, this was a third-party complaint that the commission received. She was an unsuccessful candidate for the special election for State Senate District 21 that just happened.
Before you go any farther, Ms. Judd,
Yes,
were all of these Senate 21 filed by the same complainant?
yes.
Was it
Was-
someone, oh, sorry.
Was he a candidate
He-
in this race?
He was not a candidate, but they were all filed by the same person.
A concerned citizen, Commissioner.
Was there any indication of political involvement by the complainant? Was
Not-
he involved in any other campaigns in this, or was he involved with a campaign in this race?
Not that I'm aware of.
And do we have any plans as a commission for a rule in the middle of a campaign to have something like this filed and the appropriateness of something?
So, this past legislative session, part of a bill that did go through would sort of ice or restrict complaints being filed within 60 days of an election. Now, that doesn't mean they're rejected. It just means we don't officially accept them within the 60 days of the election until the election's over.
Well, regardless,
Yeah.
it attracts your attention, and certainly politics is political.
Right.
So it's just interesting. And I certainly, let me give a shout out to the staff at this point. The timeliness and the appropriateness of yours on all of these cases was exceptional. So to have them here, and that Senate seat is not even yet decided, is extraordinary. So thank you.
Thank you. So I guess to go off, we have 5 cases that all have the same violation. OCGA 21-550A for failing to file their PFDS, personal financial disclosure statement, within 15 days of qualifying, and they were all by the same third-party complainant. Ms. Dunigan's complaint was resolved with a $250 penalty, so $125 late filing fee and a $125 civil penalty. She's already paid that, and she's in compliance.
Item P, case number 25-0053-C, in the matter of Deborah Shigley.
Ms. Shigley has the same violation for failing to file her PFDS within 15 days of qualifying. She received a $250 penalty, a $125 late fee, and a $125 civil penalty. She's already paid that as well and is in compliance.
Item Q, case number 25-0054-C, it's in the matter of Steve West.
Mr. West is another one of those candidates in violation of 21-550A for failing to file his PFDS within 15 days of qualifying. He received a $125 penalty, so that was a $125 late filing fee. His was distinguished given that he had a prior position, and his counsel reached out with confusion as to when they were supposed to file, given his prior seat and given local filing versus state filing. So we tried to take that into consideration and as mitigation in this matter and assessing the late filing fee for that filing document.
Was it different?
It's the
Trying to
same,
scroll, sorry. Go ahead.
it was the same, I'm sorry, what different?
The fine, the late fee and the ultimate
Yeah,
amount.
I'll just go ahead and address this up front. 3 of the 5 are being fined a total of $250. 2 of the 5 are being fined $125. The reason for that is the 2 that are being fined the lesser amount were already in elected office at the local level and believed that by filing a financial disclosure for that local seat, it satisfied the requirement for the state seat they were running for. It's a reasonable assumption. That's why we're giving some deference there. But the law, the trigger for each requirement is different. And so the financial disclosure for the state Senate seat was not satisfied by the local financial disclosure. Commissioner Thompson.
That may be an item that in future training.
Sure.
That you raise that issue with somebody that's already in office, that they need to be aware if they choose to become involved in some other race, that
Yeah.
the rules apply to them as well.
I think we're moving to item R. It's case number 25-0055-C in the matter of Lance Calvert.
Mr. Calvert is another one of those candidates who violated OCGA 21-550A by failing to file his PFDS within 15 days of qualifying. He received the $250 penalty, the $125 late filing fee, and the $125 civil penalty. He has already paid that fine, and he's in compliance.
Here's something I guess that I question with these, with these amounts being different. I understand, what Mr. Amati just said. So if I'm the last one to actually agree out of the 5, am I entitled to know what person C's fine, is going to be?
Entitled?
Well, yeah, if I ask and say,
Yeah,
hey, what did person C get?
I don't think we're required to tell anyone, no. I certainly don't think they're entitled to that information. Now, practically, if someone says, well, someone else did the exact same thing, what did they get? We'd probably say the same thing we're offering you, right?
So, but so if somebody came and asked that I want a global agreement, whatever they get for the same violations that I should get. So,
I don't know that we're required to,
I don't know that you can because it's not an open record yet.
yeah.
And because your consent order is a suggestion, because it's not.
Yeah, it's not,
it's
just
not-
because we sign it doesn't mean it means anything until the 5 members agree.
No, but if I'm,
It's like
if I'm Mr. Calvert, then, I guess I'm going to come to the meeting. And when I hear that, other folks are paying less than me, I'm going to stand up and say, I'm withdrawing my consent order.
I mean, if he wanted to drive to Savannah for $125.
All right. Well, I mean, it could certainly happen where those fines are
Sure.
much larger.
Sure.
All right. Item S, case number 25-0056-C. That's in the matter of Brian Will.
Yes, and he had the same violation for OCGA 21-550A for failing to file his PFDS within 15 days of qualifying. He was the other candidate who had a confusion regarding his prior local seat, so he was assessed the $125 late fee.
Mr. Thompson?
Yes. So in here, and I lost it where it said, does it not say that the filing officer confused him at the direction of the filing officer, or I just make that up in my head?
No, I think that's right on the Will case, right? Was
Right.
the one that got bad information from the local clerk?
I wouldn't say it was bad information, but yes, he did receive an email from the local filing officer instructing him to file on July the 1st, which would have been his filing deadline in Alpharetta. However, at that point, the 15-day deadline had already passed.
Oh, that's right.
Okay. Item T, it's case number 25-0059-C. It's in the matter of Michael Shane Howard.
Mr. Howard's complaint was staff initiated. He was a part-time Solicitor General in Washington County. He ran in 2020 and the 2024 general elections. He was the incumbent both times and ran unopposed. He had a total of 12 violations. He violated OCGA 21-534 9 times by failing to file different campaign contribution disclosure reports. 2 of those CCDRs were election year CCDRs and 7 were non-election year CCDRs. He also violated OCGA 21-550A 3 times by failing to file his 3 different PFDSs for calendar years 2020, 2021, and 2023. He was assessed a $2,000 penalty, so $1,500 in late filing fees and a $500 civil penalty. He immediately was cooperative through his counsel, Mr. Wilson. I communicated with them multiple times. They provided that he did not raise or expend any funds since he was running unopposed, and this was a part-time position, so he did not have any campaign funds at all, which is why he didn't think that he was obligated to file despite having filed the DOI.
Did he file a 2022 PFDS?
Yes,
So he knew he had to file them.
yes.
Move to item U.
So I think he was unsure about the CCDRs because he misunderstood that since he didn't spend or expend any money or raise any funds, that he didn't have to file the CCDRs. Sorry for the clarity.
Okay. Item U, it's case number 25-0067-C in the matter of William Whaley.
Mr. Whaley's complaint was also staff initiated. He was the successful candidate for Blue Ridge City Council Post 4 in the 2021 election cycle. He violated OCGA 21-534 C2A 2 times by failing to file his September 30th, 2021 and October 25th, 2021 election year CCDRs. He was assessed a $500 penalty, so $250 of late fees and $250 civil penalty. Mr. Whaley's complaint was initiated after he essentially self-reported. He wanted assistance with some of his filings, and that's how we were able to assist him and go through what he needed to do. But he was entirely self-funded, and it was a small campaign.
Item V, case number 25-0063-C in the matter of Terenia Carthen.
Ms. Carthen was a staff-initiated complaint. She held a position in Douglas County as Douglas County Commissioner for District 3 and was reelected in the 2022 general election. She subsequently resigned from that position on February of 2024 and filed a new DOI and ran for Douglas County Commission Chair in the 2024 primary election. And she was defeated in the primary election. And essentially, after she was defeated, she failed to continue to file for the commission chair post. She violated OCGA 21-534 7 times total. As a District 3 commissioner, she missed 3 CCDRs. 1 of those was an election year, 2 were non-election year. And then the remaining 4 missed CCDRs were for after she was defeated in the primary. She did not continue to file. Her penalty was $1,500, $875 in late fees, $625 in civil penalties. She was immediately responsive, cooperative, and turned over all of her banking records. And she is working on getting that fine together and terminating her account.
Okay. Looks like the last one is item W, case number 25-0062-C in the matter of Sonia Compton.
Ms. Compton was a staff-initiated complaint. She was the successful candidate for Douglas County Solicitor General in the 2018 general election, and then she re-ran in 2022, was reelected to her position. She did have opposition in the primary, but she ran unopposed in the general. She had total 7 violations. She violated OCGA 21-534 5 times by failing to file her CCDRs. 2 of those were election year CCDRs, 3 were non-election year CCDRs. She also violated 21-550A twice by failing to file her 2022 calendar year PFDS and her 2024 calendar year PFDS. Her penalty was $1,500, an $875 amount in late filing fees, and a $625 civil penalty. She was also immediately responsive and cooperative. She turned over all of her bank records. She elaborated and explained she wanted it in the consent order that several of her missed filings in 2022 was due to a battle with cancer, and she asked that that specifically be notated in her agreement.
Do I have any questions, comments, or concerns from the commissioners with regard to any of the consent orders that have been presented this morning? Hearing none, I'm going to make a motion that we adopt all of the consent orders with the exception of case number 23-0017C in the matter of Edward Ted Terry and case number 25-0057-C in the matter of Miriam Paris. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor of adoption, say aye. Aye. Any opposed? Those are adopted. Just very quickly, with regard to Edward Ted Terry, under the findings of fact, on the second line, there's something that just said he filed his. I'm going to strike through that and initial it. With that change, I'll move that we adopt the consent order in case number 23-0017-C. Do I have a second?
Second.
Got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? All right. Next is going to be in case number 25-0057-C in the matter of Miriam Paris. First line under findings of fact, it says respondent has served on the Georgia State House of Representatives. I'm going to amend that and just make it in. With that change, I'll move to adopt the consent order. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Aye. Any opposed? All right, those two are adopted. We'll move on to item 4 on the agenda. It's the administrative dismissals. I assume that everyone's had an opportunity to look at that information. Mr. Amati, do you have anything to be presented? Oh, is Mr. Knittel going to do it?
No, he's getting ready for the rule.
Oh, okay, I was wondering what it.
No.
Is there any discussion or anything with regard to any of the administrative dismissals included?
There's nothing to present.
Okay.
Are we going right to the vote?
We don't even vote on these.
Well, in an abundance of caution, I'm going to recuse myself in the dockets in the matter of Debbie Dooley.
Item A,
And
2018.
just regardless of the action of the commission and the recommendations of the staff, I would have recused myself regardless of the recommendations.
And we'll note that for the record, Commissioner. Okay, we're going to go ahead and move on to item 5 on the agenda. We've got a rule for consideration. First, before you start, Mr. Knittel, I know that the statute calls for or allows any written statements or comments to be submitted with regard to the proposed rule. Have we received anything?
Not that I'm aware of, no.
No? Okay. Is there anyone present from the public that wishes to speak with regard to the proposed rule? Hearing none for the record. Go ahead, Mr. Knittel.
Thank you. So the purpose of this rule is to make clear that a political action committee is always required to maintain an isolated bank account or a separate segregated account in the name of the political action committee from the time of its inception until its termination. But the political action committee is only required to register with the commission and report once it surpasses the aggregate $25,000 in contributions expenditures threshold as we previously had. This came about because there was a change with Senate Bill 199, and we were looking to provide some clarification for PACs as to when they register, and just to clarify that they have to have that isolated bank account at the inception of the PAC.
I'm not trying to shut you down already, but where was the change this legislative session in the statute?
Let me grab my other binder.
Okay. Was E1 added?
I believe E1 was added.
Yeah.
Okay. Well, the history actually says it rewrote the code section, but it was my understanding that the gist of the Senate bill was with respect to E1, but am I wrong?
You're wrong. No, you're not wrong. It's, yeah, so it is specifically with E1. That's correct. I just want to verify I had the correct subsection. I had the correct subsection for you there.
And I guess we better refer to it as E point one, or.
It's E.1.
E.1.
Because there is an E1 also, but so we're talking about E.1.
E.1, yes.
Okay, all right.
See, this is
So-
what was added.
So I'm going to go ahead and ask you sort of some of the questions that I have with regard to this.
Yes, sir.
Okay. So we had subsection E, 1, 2, and 3 before this past legislative session, right? And subsection E sets forth a rule, right?
Yes,
And then it's got 3 exceptions that are listed. Is that right?
correct.
So then E.1's added, and there are no exceptions applied to it. And so what we're here for today, are we trying to apply the 3 exceptions to E, subsection E, down to E.1? I mean, isn't that essentially what we're doing?
I think we're doing is clarifying, because there's some inconsistency with E.1 in the prior section with regard to the $25,000 threshold. That was one of the areas.
I
But I
think,
see that in subsection E. I don't see that in subsection E.1. That's my whole concern about the rule, is I feel like we've got E.1 now, and we're trying to say, oh, well, the exceptions in E1, E2, and E3 are now also applying to E.1. But if the legislature intended those 3 exceptions to subsection E to apply to subsection E.1, I feel like they would have put that in there.
You've met the legislature, right?
Hey, don't put me in that boat you just stepped in.
I'd like some clarification here. So I'm reading where, on the proposed rule, and I'm understanding this is a rule that we're contemplating to promulgate, right? We're making this rule. And it is a rule we're making to apply the statutory authority. I want to understand what we're doing. That's what we're doing.
Again, that's my understanding as well.
Okay, sure, and I'm just looking at you.
Yeah.
Maybe I should look at Mr. Knittel. So when I read the words, it says struck through text is proposed to be deleted, and underlined text is proposed to be added. I'm not quibbling, I'm trying to follow it. I don't see any struck through text. So I just want to be sure I'm reading this correctly. This is a,
You are. This is a new rule. We're not striking
okay,
any language.
entirely new rule that we would be establishing.
Yes, that's
But
correct.
these statutes, this E and E.1, the statutory authority already exists.
Yes, the statutory authority exists, yes, that's correct.
I agree that E and the E.1 is, I might not have named it that way.
That's why I was struggling with
Yeah.
it, initially there. But is my analysis of this, is it off? Because if it's off, I want to make sure that I'm reading this correctly. Because it seems like the rule that's proposed today is an effort to apply the 3 exceptions to subsection E to the new subsection E.1. And I just feel like if the legislature intended that, it would have said somehow or made reference to the fact that the 3 exceptions to subsection E, which were already there, somehow apply to the new subsection E.1. I know that sounds very confusing, and I really wish they wouldn't have done it that way.
I think they could have, yes, they could have crafted this better. But I don't know that you can, I don't know that you cannot apply the exceptions to E.1. It's the same concept of the political action committee. It's the same legal entity. So I don't know how you apply those exceptions in E but not E.1. That is part of the clarification that the exceptions do apply in E.1 as well. You're right about that. The other clarification is when the bank account, which now has to exist, has to go into effect. So it's a two-pronged intent behind the rule.
I get that, because I read right here that, it's got to be opened right off the bat.
Right.
I agree with that. My only hesitation with this is that I don't know if we have the authority to apply those 3 exceptions to E.1, because there's no, relationship in the statute between those.
May I ask a a more basic question? What's the consequence if we do or do not establish this rule? Because we've got, the law is the law, right?
Right. We'd continue giving informal guidance when people call and ask versus having something in authority to hand them. Because we have had a lot of PACs wanting direction, both state and nationally, on how they have to register, when they have to register, how they have to set up the financial institution. It's a question we're getting more and more of.
And it wouldn't be, or would it be appropriate if somebody inquired to just direct them to OCGA section 21-5, et cetera?
We do inform them of the statute. A lot of the times they are lay people and non-lawyers, and so it's a little unfair for us not to try and help out. And we do have an education division for that purpose. But we do direct them to the law in any guidance we give.
Did you provide a copy of the language for E.1 in the binder here?
I've got it right here if you want to see it.
Yeah, you have it, but for the rest of the commissioners, I don't, because I don't think we don't have it.
That's not part of it.
So, I know what this is, because I've read it, but
Tell me, I guess, and I'm not saying that I won't be convinced that this is the way the rules got to apply. Tell me why you said that that without applying those 3 exceptions, to the new language, that it just doesn't make sense.
So if you wanted to not apply the exceptions in E to E.1, I genuinely don't know how you do that. Would in E1 you be saying a PAC has to register even before the $25,000 threshold, even though in E we say you don't have to register and report until the $25,000 threshold? That's kind of how I understood your comment. Am I misunderstanding that? But if I'm understanding correctly, I don't know how you can say in E, this is the law, this is when you have to register, but not until this point, and then E1 say, actually, that doesn't apply, you have to register immediately. Those two are completely incongruous. Does that make sense? I'm comfortable if it doesn't. I've been there before.
Yeah, I'm just not sure. That's the only thing that jumped out at
Sure.
me with regard to the rule. I wish that there would have been some connection in the statute to the exceptions, that's all. And believe me, the last thing I want to do is be difficult about any of this.
Well, have we not had a conversation about, because of E.1, it's just basically saying that any PAC has to register, has to open a bank account
Immediately.
and register.
Yeah.
This is not what this is saying. You're still talking about $25,000 here. So this was my point earlier. Plus my other point earlier was, there's also something missing here. E.1 is saying prior to accepting any contributions, or making any contributions or expenses. So it has to include all three. They have to open a bank account, which I don't know how you do that, because banks do not let you open bank accounts with no money, and you can't have money if it's not a contribution. So I don't even know how you do that, but that's in the law. So, yeah, and then you have to open a bank account and you have to register. I don't know, construction of law, but isn't it because E.1 is after the exceptions that it's totally different? Because you have E, and you have parentheses 1, 2, 3, and then you have E.1 as a total different paragraph. Isn't there something you fancy lawyers say about
No, but
construction of law?
Look, that was my point exactly, is that
I
you
just said it
have
better.
3 exceptions.
I just said it better. than you thought.
Okay.
I just kidding.
But no, seriously, that's exactly what my point was, is that the exceptions only apply to subsection E and not to subsection E.1.
Agreed.
So okay. So your issue is, if the exceptions don't apply to E.1, how can we promulgate a rule within E.1 that deals with the exceptions?
You're applying that rule, that
Okay,
proposed rule.
okay. I'm tracking now.
Okay.
All right.
But this rule would be wrong because you're referencing $25,000.
No, that's my point exactly. That's
So-
one of the exceptions.
So is the feedback, and look, we do these in this manner for a purpose. Like, we don't divine a rule and think, well, we're just done. Is the thought process and feedback that the rule as proposed needs to be limited to essentially when the bank account has to be separately opened?
Correct.
And
The statute
leave the-
says immediately.
And leave the whole $25,000 issue
100%.
to statute?
Exactly.
I'd have no problem with that.
That makes sense.
And this also needs to say accepting contributions, because that's what the statute says.
Mr. Knittel, I mean, I have no issue with that.
That's fine.
May I ask one clarifying point for me, and I'm sorry, I don't have the depth of knowledge here. So E says any independent committee that's going to make contributions. It talks about an independent committee. And then E1 says any political action committee, again, not quibbling. Are those the same thing? Because I
No.
thought I understood y'all earlier to say they're two different things.
Yeah,
right?
correct.
Yeah, okay. So that would make it even more rational to set up E.1, because it's just saying any political action committee.
Right, I think if the staff thinks that it's cleaner to have the rule that has been proposed, next to the legislative session, I think that, you can try to
Sure.
get that, added onto the statute, but I just don't think it's there.
I take the feedback. I tend to agree with the feedback.
But why do we even need a rule if the statute's very clear? You don't need to re-articulate this
I
rule.
agree.
I don't think we need it. I know we talked about this earlier, talked about this at one time when the law first came out, because there was confusion about when do you have to do it, but if you read E.1, it's very clear, it's immediate. So,
So you just don't think we need the rule at
I
all?
don't think so. I mean, you can tell, I'm a layperson and I read it and knew it was meant immediate.
The only way that I feel like we need the rule is if there was some connection that someone can draw between E.1 and the exceptions in 1, 2, 3. Since those exceptions in 1, 2, 3 are not applied here to E.1, I don't think we need a rule. Again, If you take the new part of the statute, E.1, and you look at it, all it stands for is that you have to immediately open the account and do those other things. It doesn't have anything to do with $25,000.
Okay, I take that.
And that's starting January 1 of 2026.
Yes.
Yes.
I'm trying to remember which parts start when. Yes, that's
It's
correct.
effective, yes.
Well, the law is effective 2026, but there are parts of the bill that sunset 2027, but that section is 26.
Right, there are still parts of this statute that says, it's repealed effective 12/31 of '26.
Yeah.
So it's confusing. Anyway, I think I don't know if everyone's in agreement with that or not, and I don't know how we necessarily,
I think you just move to table it and we don't bring it back, right?
okay, if you say so. Do I have a motion?
I'll move the table.
Second.
Got a motion and a second, any discussion? I will make one quick comment about this. The fact that we disagree, please don't take that as us, imposing our will on the staff on this topic, or, something to that effect. I don't think that it was it made sense as it was presented, I guess, until I actually started looking at the way that the law was, spelled out. So, anyway, for what that's worth. I got a motion and a second, any discussion? Further discussion? Sorry. Hearing none, I'll call the question. All in favor, say aye.
Aye.
Any opposed? All right. That takes care of that. Does anyone need to take a break before we get to this AO? Okay, let's take a quick 10-minute break or so.
Okay.
It looks like we're to item 6 on the agenda. That's an advisory opinion that's for consideration. It's marked as AO 2025-01. Mr. Canetto, are you presenting?
Yes.
Did we receive any written comments with respect to the AO as, I guess, published?
We have not.
Okay. Is there anyone present here today at the meeting to provide any comment with respect to the proposed advisory opinion? I don't
No.
see anyone. Mr. Canetto, go ahead.
Thank you. This advisory opinion was in response to a request made by Brian Sells, who provided the following hypothetical set of circumstances. Essentially, the hypothetical is, we have a candidate for public service commissioner who solicits a donation of $500,000 from an independent committee to pay for the cost of airing television ads that have apparently already been produced by the candidate themselves. The candidate recognizes that the independent committee can't lawfully contribute $500,000 to the candidate's committee. And so the chair of the independent committee, with the candidate's consent and cooperation, then coordinates with the chair of a leadership committee to contribute $500,000 to the leadership committee, which then immediately pays the $500,000 cost for airing of the candidate's advertisements. And then, under those circumstances of that hypothetical, the question was, has the independent committee made a contribution to the candidate that is subject to the statutory contribution limits? That essentially is the question that was submitted to us as hypothetical.
Did you write the advisory opinion?
Yes, I did.
All right, I'm gonna say, we've had a number of these since I've been on the commission, and I would go through, and I would mark it up, and I would nitpick about various things. I did not write one single comment with regard to this advisory opinion. I thought it was well-written. I think it's dead on. I'm just letting you know, I have no comments, no concerns or anything. I know that everyone's probably glad to
Thank
hear
you.
that's the case, but I thought it was right on. You know, again, I'll let you explain it, you know, the way that you've got it laid out.
Okay.
I'll just say that as soon as I read the question, I just defaulted to, this is nothing more than an attempt to, you know, to do an end run around what the law is. That's, so, all right, go ahead.
And yes, Chair, thank you for those comments. And yes, that, with this specific hypothetical, and I say it has to be very specific set of facts, that would be the ultimate conclusion that, yes, if these things occurred, and they could be proven that they occurred in this particular manner, then that may be the key point. I'm not sure how you do that in the real world, but in this hypothetical, it makes some presumptions that there's strong evidence of coordination and things of that nature, that yes, that would ultimately be a contribution to a candidate. But part of this deals with leadership committees, and it's really not, the hypothetical isn't really looking at, leadership committees can accept unlimited contributions from essentially anyone, and they can also make unlimited contributions to a particular candidate. This is really a hypothetical that I think deals with the coordination, which we've dealt with in many prior cases, coordination between a candidate and the independent committee, which is not allowed. But I think it's important to note that, just if there was simply this fact pattern that there's a, that we take the fact pattern where there's a candidate that produces a television ad, independent committee transfers money to a leadership committee, and then that leadership committee pays that, that's not enough. That's not enough. That's just money in and money out. And the money that the leadership committee has, every dollar is the same as every other dollar. We can't say that it's from a particular independent committee necessarily that they're using that. So I'm not certain when we would have this set of facts to be able to prove this hypothetical. So I just think it's important to note that there's a strong presumption of the evidence of this taking place in order for this to be that wink and nod agreement, so to speak.
You'd almost need some evidence of overt communication between actors within the campaign and within, the big money spenders, right? You need something you could point to and say, there's evidence of a link
Yes.
right there.
And-
That
and-
email, that text, that call, whatever it is.
Right.
Correct. I would agree with that statement, Mr. Motti. And so, I'm not sure what else you want me to talk about on this. I think it's pretty clear in here.
Does anyone have any questions or comments? Again, in terms of this analysis, this is like worst-case scenarios, the way that I look at this. It's, it's like 100% coordination, no question about it.
Yes.
And I think that's what it's going to apply to. Otherwise, it's going to be a fact-specific case.
Yes.
Yeah, okay. Any questions, comments, discussion with regard to the presented advisory opinion? Hearing none, I'll make a motion to adopt the advisory opinion as presented. Do I have a second?
Second?
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right, that's a handling an advisory opinion in record time.
I hope that's a good thing.
No notes.
I think you drove that bus.
We'll move to item 7 on the agenda, is the report of the executive director.
Yes, thank you, Mr. Chairman. I'm going to talk about two things. This is the sort of annual update I give on sort of the case status update numbers, financial related numbers to the cases. So as of present, we have, as of last calculated, 114 existing cases that are under investigation in the office. When we started 7 years ago, that number was 380. So about 7 years ago when we came in, there were 380 active cases, and that number was pretty consistent moving backwards. We have, over the years, whittled that down. This is the lowest case count we've ever had in our time here. But what I do want to point out is while our case count is lower than it's ever been, compared to, say, that 380 figure from the high water mark 7 years ago, we're actually receiving and initiating more complaints ourselves than we were at that time. So without getting too wonk in the weeds, we truly are churning through cases at a much more efficient and effective rate. We're receiving more from the public, which I think is part and parcel of the fact that we're doing more and people see that, so they have more faith to reach out and say, hey, I've seen something, I know something, can you help? Can you do something? I'm very happy with the case count. I'm not going to sit here and say we have no cases that are too old. For example, we currently have, well, I don't break it down there. This past year, we resolved 8 cases that were over 2 years in age. The year before, it was 50. So we've really churned a lot of that backlog. There's always going to be cases, whether it's tied up in litigation, Superior Court, federal courts, what have you, that will inherently take longer. But again, I'm just very pleased with the work of the staff and the job they're doing, because we're in a really healthy place in terms of our work product. Related to that are the financial figures that accompany those cases. In the last fiscal year, the last 12 months, the total amount that we've collected and remitted to the state treasury is $328,000 and change, which is about $40,000 higher than it was in the previous calendar year. Now, there's some ebb and flow to that. Obviously, a big chunk of that was the $300,000 fine back in January on the pro-Abrams super PAC. So that has inflated that number some. But prospectively, I do think we are going to see an increase in monetary funds collected by the agency, because while we've collected more in the last year, we have not really collected a lot in terms of lobbyist late fees because of technical issues we've had with the system. So when the new system goes live here at the end of the year, I think we'll be able to do a better job of sort of spotting that and hitting those. So my hope is that these big fines that we tend to collect can inflate and skew the total, collected and remitted to the Treasury. But my hope is, even given that fact, I think we're going to see an increase in late fees and fines collected. My hope is this new system will help us auto flag some violations better than our current system does. So I'm not expecting a huge decrease in the next 12 months in terms of what we're able to do and enforce. That's really all I wanted to present at this meeting, Mr. Chairman.
Okay. Any questions, comments, or concerns for Mr. Amati?
I will where does the new system stand?
Yeah, so what do we call it, a soft launch? We have a soft launch in 2-3 weeks? Monday, okay. All right, we have a soft launch Monday where we're going to be rolling it out with certain filers that we know have big accounts, right? And so like, I think internally our thought is if the new system, we start having people register with the bigger accounts, we're not seeing issues, we feel much more comfortable with, the smaller, easier to contain. So the beginning of the launch is Monday. I think that the sort of tentative plan is by the end of the year, everyone will have been registered, able to start entering data, and ready to disclose going into January of next year. And that will be true of the campaign disclosure side of things. The financial disclosure side of things will be right after the new year. And end of the year will also be true of the lobbyist module. So by the end of the year, everything should be up and humming. That's sort of the update.
Will existing data get transferred over, or is that going to have to be archived? Or is that to be determined?
It's going to be optional. There are people who are going to want to roll over that data, and in that scenario, that is ideal. There are going to be people who have had issues with the technology, through no fault of their own, to be clear, that they're going to say, I just want to start clean, and we're giving them that option as well. And we have a good idea of whose accounts have been bugged for a few years, so we know who the people that are having problems are.
Okay.
Ms. Young, report of the Attorney General's office?
Yes, hi, can everybody hear me?
Yes.
All right. We don't have a whole lot to report on this week, for this meeting. We've got our normal enforcement cases percolating along. There is one hearing that I did want to draw to your attention because largely about timing. It is scheduled to be heard on September 25th in Macon. And a lot of times when we notice a hearing at OSA, that ends up resulting in a settlement. That something about that hearing notice tends to make people suddenly get a lot more cooperative. This is not one that I am expecting to settle. So we are planning to head down to Macon next week with Mr. Baywell to have a hearing in this case, but it's sort of that perfect timing of when that would probably result in the decision from an ALJ. And
Remind me of the issue.
so the underlying case is a fairly simple one involving failure to file CCDRs and some anonymous contributions. But we have the timing issue that I'm referring to has to do with the board's ability to review an ALJ decision. And for our newer member that may not be familiar, when we take a case to the Office of State Administrative Hearings, we have a hearing, and then an administrative law judge will write an initial decision that will come in about 30 days later. So we are having a hearing on September 25th. That means, sometime on or before October 25th, we ought to get an initial decision from the ALJ. This commission has the right to review those decisions and can substitute its own findings of fact or conclusions of law for the ALJ's opinion if it chooses to do so. If it does not act within 30 days of the initial decision, however, it becomes final by operation of law. The commission can enter an extension for the first 30 days after that. But what is problematic about the timing in this sort of scenario is that we're likely to get an opinion from the ALJ kind of mid to late October, which means that it would become final by operation of law kind of mid to late November, probably right around Thanksgiving. And before this board is scheduled to regularly meet again. So it makes it a little less convenient. Ideally, we try to think about timing. And in fact, I have several cases that are ready to go to OSA, and I'm waiting just a little bit, to try to get opinions that would drop a little bit later, like more toward late November, so that then this board could just put it on the calendar on the regular agenda for the December meeting. It's not going to be able to do that for this one. Much of the time, if not most of the time, the opinions that we get from ALJs are perfectly appropriate and don't require this board to do anything other than allow it to become final by operation of law. But I did want y'all to have that on your radar screen, that when we get this opinion in October, assuming the case doesn't settle, which we do not expect, that's something the board's going to want to look at quickly, and if it feels like that there's a discussion that needs to be made, the board can either set a special session, or it can enter into, under OCGA 501341, it can do a 30-day kind of continuance. And we have done that in other cases in the past. Mr. Amati can help make that happen if needed.
Yes.
But I just wanted to make sure that y'all are aware of that. We also have had a couple of cases that are ready to go to OSA that we've, had some concerns about from a financial standpoint. It's not a problem when they're in the metro Atlanta area and travel is not concerned. But, when we have cases that require travel and hotel costs, it sometimes, makes us wonder whether it is viable to bring a case to OSA when the amount of the penalty is perhaps likely to be less than the cost of bringing that dose. And we've been discussing that with Mr. Knittel and Mr. Amati, and we're hoping maybe for the next meeting to have some proposals that we can discuss with the commission in terms of alternates for resolution. Because right now, we sometimes are able to work out consent orders, and in fact, we've got, one that was exactly like that with Mr. Kilgallen on this meeting's consent order, where, we kind of took into effect the cost of trying the case, and we happened to have a cooperative respondent that was willing to pay a penalty. When we don't have a cooperative respondent, that's not responding to our inquiries or is just recalcitrant, really our only option is to take it to OSA with all of the costs that are involved. We think we have some alternates that this board hasn't done in the past, and I've been discussing with Mr. Amati maybe some proposals that we may bring to you at the next meeting for ways to resolve those types of cases that that would not involve having to go to OSA, but would not be just dismissing a viable case. So
I certainly understand what you're saying, but I also don't want to send some message out there that, well, as long as it's going to be a minor violation, you're never going to have to, pay your fine or your penalty or what have you. I wouldn't want that message to get out there.
that is true, and that's one of the things that we've been discussing is, what do we do in those situations where, the economic analysis raises questions. It does not tend to come up so much in the metro Atlanta area because, we can, do the Office of State Administrative Hearings has space there and does not require travel time and hotel costs. But when you're talking about paying for somebody from our staff and then somebody from the commission staff to travel and the OSA judges to travel, that can be a fairly pricey endeavor. So
Okay.
we do have a few cases that are stuck right now with us without a clear off-ramp in terms of, how those should be handled.
Okay.
All right.
Anything further, Ms. Young?
No, we are about to institute a subpoena enforcement action in Fulton County Superior Court seeking to enforce a subpoena against a company called Pegasus Strategies, which is a Florida corporation. So you hopefully will hear back, in terms of that enforcement action at the next meeting.
Okay. Any questions for Ms. Young? All right. Hearing none, we're going to move to item number 9 on the agenda. It's executive session. I'll make a motion that we go into executive session to discuss legal matters pursuant to OCGA 5014-2-1. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Aye, sorry. Any opposed? All right, motion is granted.